Good day everyone. My name is Maxine Joyce B. Foha and I will be tackle the Rule 119, Section 10 and Section 11.
Section 10. Law on Speedy Trial. Not a bar to provision on speedy trial in the Constitution. No provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14 to Article 3 of the 1987 Constitution.
So, this section of the Rule 119 assures that the right to a speedy trial as guaranteed by the Section 14(2) of the Article 3 of 1987 Constitution will always be unaffected by other laws or rules governing the same. So, this provision emphasizes that no statutory provision or procedural rule on a speedy trial should be interpreted in a manner that obstructs or diminish an individual's entitlement to the constitutional guarantee of a swift and impartial trial. All in all, this rule generalized constitutional principle of a fast trial that must always be respected while interpreting and applying procedural rules and statutory regulations that specify a specific timetables or methods for accelerating trial proceedings, which means Rule 119 Section 10 protects people's fundamental rights in the criminal justice system by ensuring that any laws or rules pertaining to a fast trial are supportive of and subject to the constitutional obligation.
Section 11. Order of Trial. The trial shall proceed in the following order. A. The prosecution shall present evidence to prove the charge and, in the proper case, the civil liability.
So on this section 11, letter A, outlines the responsibility of the prosecution during a trial. It mandates that the prosecution must present evidence to substantiate the charges brought against the accused. Additionally, if applicable, the prosecution is also required to provide evidence supporting any civil liability associated with the case.
B. The accused may present evidence to prove his defense and damages, if any, arising from the issuance of a provisional remedy in the case.
While in this section 11, letter B, grants the accused the opportunity to present evidence supporting their defense during a trial. Additionally, if relevant, they can also introduce evidence to demonstrate any damages incurred due to the issuance of provisional remedies in the case.
C. The prosecution and the defense may, in that order, present rebuttal and surrebuttal evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue.
So, in this letter C, outlines the procedure for presenting rebuttal and surrebuttal evidence during a trial. Initially, both the prosecution and defense have the opportunity to present their respective evidence in support of their positions. Following this, rebuttal evidence, which directly responds to the evidence presented by the opposing party, may be introduced. Subsequently, surrebuttal evidence, which addresses new points raised in the rebuttal phase, may also be presented.
D. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda.
So, in this letter D, it established that once all evidence from both the prosecution and defense has been presented, the case is considered concluded and ready for a decision. However, the court reserves the option to request further clarification or arguments from the parties, either through oral presentations or written memoranda, before rendering a final decision. This provision ensures that all relevant information is truly considered before reaching a verdict, contributing to the fairness and completeness of the judicial process.
Lastly, E. When the accused admits the act or omission charged in the complaint or information, but interposes a lawful defense, the order of trial may be modified.
Lastly, the Section 11, letter E, allows for a modification of the trial sequence when the accused admits to the act or omission described in the complaint or information but asserts a lawful defense. In such cases, the typical order of trial, where the prosecution present evidence first followed by the defense, may be altered. This provision acknowledges situations where the admission of the fact or omission is not disputed, but where the focus shifts to the validity of the defense raised by the accused. As a result, the trial process may be adjusted to accommodate these unique circumstances, ensuring that justice is served effectively and fairly. Overall, the Philippine legal system trial proceedings are governed by the Rule 119 Section 11, which acts as a guide. It lays forth the parameter for introducing evidence and making arguments in front of the court, as well as the duties and responsibilities of the prosecution and defense, which means by establishing a clear guidelines for the conduct of trial proceedings, Rule 119, Section 11 promotes fairness, efficiency, and the orderly administration of justice. It ensures that both parties have an equal opportunity to present their case and that the court has the necessary information to render a well-informed decision. Ultimately, this provision contributes to upholding the integrity of the judicial process and safeguarding the rights of all parties involved in criminal proceedings.
And that's all for today. Thank you for listening and have a great day ahead.
So, good morning everyone. Today I will be explaining the Rule 119 of Criminal Procedure, specifically the Section 10 and 11. So, first, Section 10, Law on Speedy Trial not a bar to provision on speedy trial in the Constitution. No provisions of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14, Paragraph 2 of Article 3 of the 1987 Constitution. So, what is really meant by this Section 10 of Rule 119? So, this means that the law on speedy trial and its implementing rules cannot be used as a defense against a charge of denial of the right to speedy trial as protected by the Constitution. Furthermore, the right to a speedy trial is a fundamental right guaranteed by the Constitution to all persons accused of a crime. This right is designed to prevent prolonged detention of accused persons and ensure that they receive a fair and prompt trial. The Constitution sets forth the time limits within which a trial must commence, and these limits are generally enforced through the rules of criminal procedure. However, the rules of criminal procedure cannot be used to circumvent the constitutional right to speedy trial. This is why Rule 119, Section 10 states that no provision of law or rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial is guaranteed by the Constitution. This means that if an accused person believes that their right to a speedy trial has been violated, they can bring a charge of denial of the right to speedy trial under the Constitution. And this charge cannot be dismissed based on any provision of law or rule implementing the speedy trial. In summary, Rule 119, Section 10 of the Revised Rules of Criminal Procedure is a provision that ensures that the right of a speedy trial is guaranteed by the Constitution, cannot be undermined by any provision of law or rule implementing the speedy trial. It is guarant it is safeguard that protects the constitutional rights of accused persons and ensures that they receive a fair and prompt trial. So that is the section 10 of Rule 119. So let us proceed to section 11. Section 11. Order or Order of trial. The trials shall be proceed in the following order. So letter A, the prosecution shall be present evidence to prove the charge and in proper case the civil liability. Letter B, the accused may present evidence to prove his defense and damages if any arising from the issuance of a provisional remedy in the case. Letter C, the prosecution and the defense may, in that order, present rebuttal and surrebuttal evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless, unless the court directs them to argue orally or to submit written memoranda. Letter E, when the accused admits the act or omission charged in complaint or information but interposes a law defense, the order of trial may be modified. So this section sets out the general procedure of the presentation of evidence and arguments in a criminal trial. So the prosecution is responsible for presenting evidence to prove the charge, and the accused has the opportunity to present evidence to prove their defense. The prosecution and defense may be also present rebuttal and surrebuttal evidence, and the court may allow additional evidence to be presented if necessary. So, pag kailangan lang po. So, once the evidence has been presented, the case is submitted for decision unless the court directs the parties to argue orally or submit written memoranda. So, kapag kailangan po talaga ng mag-submit ng written memoranda, so the court will require the both parties to submit the written memoranda or orally. If the accused admits the acts or omission charged but raises a lawful defense, the order of trial may be modified to accommodate this. Overall, Section 11 of Rule 119 provides a clear and orderly process for the presentation of evidence and arguments in a criminal trial, ensuring that all parties have an opportunity to present their case and that the trial proceeds in fair and efficient manner. So that's all the Rule 119, specifically the Section 10 and 11, and thank you.
Section 10. Law on Speedy Trial not a bar to provision on speedy trial in the Constitution. No provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14, Article 3 of the 1987 Constitution. So, this section says that no law or rule about speedy trials can stop someone from claiming their right to a speedy trial under the 1987 Constitution. So, even if there are rules about how fast trials should be, they can't ignore the constitutional right to a speedy trial. Next is Section 11, Order of Trial. The trial shall proceed in the following order. So, letter A, the prosecution shall present evidence to prove the charge and in the proper case, the civil liability. So, the prosecution presents evidence first to create the charges against the accused and, if applicable, to prove any civil liability. This is because the burden of proof lies with the prosecution as they are the party bringing the charges against the accused. By presenting evidence first, they lay the foundation for their case simply because it's their job to prove the case. Next is letter B. The accused may present evidence to prove his defense and damages if any arising from the issuance of a provisional remedy in the case. So, the accused is given the chance to present evidence to support their defense because it's important for them to have an opportunity to respond to the allegations brought by the prosecution. This ensures fairness in the legal process and allows both sides to present their arguments and evidence before the court makes a decision. So next is letter C. The prosecution and the defense may, in the order, present rebuttal and surrebuttal evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. So both the prosecution and defense are allowed to present rebuttal and surrebuttal evidence to address each other's argument and evidence. This allows for a thorough examination of the issues and ensures that all relevant evidence is considered before the court makes a decision. This is to ensure fairness in the legal process by giving each side an opportunity to respond to the arguments and evidence presented by the other party. Next is letter D. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. So, after all evidence is accepted, the case is ready for a decision unless the court wants to hear spoken arguments or get written notes from the parties. This lets the court review the evidence and give time to think before deciding. Last is letter E. When the accused admits the act or omission charged in the complaint or information but interposes a lawful defense, the order of a trial may be modified. So, if the accused says they did what they're accused of but has a good reason, the trial order might change to fit this. This helps the court focus on the relevant issues and consider the defense raised by the accused.